not surprised that it's done that way. There has always been on the issue of admitting fresh evidence. Yes, it is possible, but probability is a different question. On the issue of 25% of Abuja, of course, from day one, I had consistently said that is not the law, and what the Supreme Court has said now is the true position. The expectation, the intendment of the Constitution as expressed. I think that those things were just being taken out of context, and too much energy was being devoted to them. I expected them to devote energy to proving the allegation of stolen votes, and if there were non-existing votes that were counted, you prove them to establish a claim that the election was won and that it was stolen.
Yes, the matter is done, talking about the 2023 electoral process at the presidential level. However, this evidence sourced by Atiku and the PDP, can we say it is still useful, not in the immediate, but in the future? Is it still useful? Because the Supreme Court did not necessarily touch on it. So could it be used maybe in 2027 pre-election matters to disqualify the candidate?
Yes, when we spoke to that, I told you, yes. Something that is not used now can be used later if it is established to be what it is alleged to be. And in that case, by that time, they won't wait until the matter has gotten to this level. They will bring it as a pre-election matter.
Okay.
Yes. So there will be no question of one thing or the other not happening or wrong timing and all that. They will have opportunity to raise it at the right time, under the right circumstance, and get pronouncements on it. So it's not the end of the road for anybody whose interest is ensuring that the current president does not have a chance of coming back. You have to go on and pursue and find whatever you want to find. Just make sure you are finding something that exists. Because if you look at even the application that was filed in the United States asking the court for approval that the agencies release documents. It's talking of documents if they exist without certainty. And when the court that was approached for an interim order for immediate release of the things ruled on it, it said, you're not even asking of something you know exists. You're saying something that may exist, that you believe may exist. So, if it is possible to find something that exists that constitutes a disqualifying factor, as I have said, you need to take steps to get whatever certificate of challenge notified on the grounds that it is not raised properly. It was not raised the way it was supposed to be raised. If you want to use documents as a disqualifying factor, you will have the time between now and then to get the documents if they exist. And to possibly pursue another suit to get the existing certificate from TSU declared invalid. You have time to do all that, so that in invalidating that certificate, you can now come with the judgment of the court that proves that certificate invalid and apply it here. Otherwise, if you continue in 2027 to speak remotely, acting on things that are remote and not directly related to what is going on here, you may face the same challenges.
All right.
So if they can confirm what they are alleging, get all the proofs, yes, in 2027 it can come handy to them.